But Roy, a lot of you, Roy, this is happening to me now too. I'm getting quite old, so right now, I think some people are connected. They're actually Googling you right now to see who you are. So in terms of introduction, most people here have already probably read about you. But Roy is very well known for a lot of big cases, but one of the biggest cases was the Kennedy case out of Palm Beach. And if you ever, some of you are too young to have seen that case, but I'm sure there's still some of those clips around. If you ever get to watch that, it's brilliant, brilliant trial practice. And you can watch those, you can watch the arguments, you can watch cross-examination. Thankfully, I'm getting into that old age now where I did get to watch a lot of that. And a lot of us have grown up looking at Roy and saying, you know, I want to be like him. In particular, I want to make as much money as he's making. So unfortunately, you're not going to do that in the public defender's office. So please stay in the public defender's office. But Roy, if you could come up and address these folks, we're extremely fortunate to have him here. I am extremely sorry that I'm not ready to introduce you because I didn't know I was going to be introducing you. I would have prepared better remarks, a lot better remarks that you deserve. Thank you so much for being here with us.
Two weeks ago, I was reading the New York Times. And I'm sort of an obsessive-compulsive person. I love reading newspapers, and I get the hard copies. And one of the things I do is reading obituaries. I love obituaries. There's something that connects you with people, even if they're dead. Because they're like mini biographies. They tell you about all kinds of interesting things that people do, whether they're poets, they have some of their poetry, or psychiatrists, or lawyers, or doctors, or engineers. It's always interesting. So I'm reading the obituaries, and right next to the obituaries is a classified section. Now, I didn't even know they still had a classified section, let alone in the New York Times. So I started reading it, because this was really something unique, I thought. And among the classified was an ad by Amazon seeking a coder in its programming department. And it got me thinking. First of all, why would Amazon be advertising for a programmer in the paper copy of the New York Times? But even more importantly, would you actually want to hire a programmer who read the paper copy of the New York Times? And so that got me into what I'm going to talk about today. 1987. We, ladies and gentlemen, we trial lawyers are on the cutting edge of 1987. Before I get to that subject matter, let me just say a personal note. That it is a real pleasure to be here this morning to talk to fellow trial lawyers, people that we all have the same experiences, come from the same places, mainly believe the same kinds of things. In the first 5 years of my career, I worked as an assistant public defender. Everything that I know and that I have grown into or become, whatever it may be, comes from that experience, from being in court every day, from learning how to be a trial lawyer. I thought it was probably the greatest, or is the greatest experience of my life. And I am thankful for having been hired as an assistant public defender. And because of that, it is a pleasure for me to be here this morning to speak to each of you I know who feel the same way. It is an experience, a training. It gives you that passion and enthusiasm that you can get nowhere else. Certainly not in the state attorney's office. So let me talk about 1987. That's the year that PowerPoint was introduced. Think of what has happened since then, since 1987. You have Amazon, you have email, you have blogs, you have Twitter, you have I don't know how many other digital things in the world that have happened since then. But guess what? What are we trial lawyers still stuck on? PowerPoint. How far behind the curve are we? And think about PowerPoint. What is it? You get these templates that you get to plug things into. You have lists of things. You have bullet points. It's death by bullet point. How many times have you seen a presentation where somebody puts up on the screen a PowerPoint with bullet points and then starts reading from the screen? There's actually research that when you put something up on a screen and read the same material, it doesn't enhance understanding, it distracts from understanding. And that is, I don't know how many speakers I've seen who use that as a crutch, because it's easier than preparing. All you do is you put up the PowerPoint and you start speaking about the same things or saying the same words or actually reading from it. And as I said, this does not enhance your persuasion, it distracts it. And that's what I want to talk about this morning, is persuasion and enhancing your abilities and being much more effective in the courtroom. There was a great philosopher back in the 1950s by the name of Willie Sutton. Willie was a bank robber. One of those kind of street philosophers that no doubt you deal with on a daily basis. And Willie was well known, probably in the public consciousness, for one quotation, and that was when he came up for sentencing one time in front of a federal judge who asked him, "Why do you rob banks?" Willie said, "Because that's where the money was." And of course, that probably got him an extra 5 years on his sentence. But that's not what I'm interested in. He had a much more acute observation than that. Willie said, "You can get more with a gun and a kind word than a kind word alone." And there's real genius to that. You have to look, where is your gun? And our gun, ladies and gentlemen, is what has happened since 1987. It is the digital revolution. It's the ability for us to communicate in ways we never thought we would be able to. At least I never thought I would be able to. Back when I started in the public defender's office, and way back in the ancient times of January 1971, I hate to mention that because it does seem like ancient history, and I'm sure nobody here was actually practicing, let alone being alive at that time. But it was a different time. Now let me see if this works. What I'm going to talk about is enhancements, but before I do that, I do want to acknowledge there is no greater method of communication than by speaking to people, by actually communicating, by looking at them in the eye, by talking to them, by telling them what you believe in, telling them what your feelings are. And we're going to get into some more of this as I go along here. But in no way do I want to diminish the fact that we at the basic level are speakers. But think about this. How important are pictures in our lives? Human beings started communicating by pictures. When you were a child, you learned by pictures. And I don't know about you, but whenever I buy something new, some new type of equipment, there are two different ways of figuring out how to do it. One is the manual, which is usually densely populated with a lot of words I don't understand, and when I read them, I can't figure out what I'm doing. Or they give you a diagram or a picture of how to run it. Which one are we going to use? So, I want to talk to you about a particular case, which I will get to in a minute, and that is the Michael Skakel case. Some of you might be familiar with it. He was the Kennedy cousin in Connecticut. He just got a new trial because his well-paid lawyer was ineffective, probably not as good as you guys, and the judge set aside his, 25-year sentence. But his trial was very instructive because it was the beginning, I think, of the digital revolution in the courtroom and proved how well it could work. And I think that you have to take on the job not just of sitting around and doing what everybody else does. You have to be an insurgent. You have to really take this on and push this to a new height. Because today, this is a multimedia world. This is an electronic world that your jurors are living in. Let me give you an example. This is a real case. People are running out of courtrooms because they're bored to death. They live in a different world. They are in their emails, on Twitter, on the blogs. They have all these pictures. They have all this panoply of interesting stuff that goes on in their lives. And then we drag them into a courtroom and we bore them to death. Is there any objection to people like this feeling this way? It's our fault. We're in charge of the communication. Now I have to ask you this question to see if you can answer it. What is our most important product? Does anybody know the answer to this? Yes. It's human attention. If you don't have attention, if you don't have people listening to you, if you can't break through to them, then of course, what good are your ideas? What good are your themes? What good are your arguments? How can you persuade people who don't even talk to you or not even listening to you? And what's the problem with jurors today? What are they doing? They give you probably 3 or 4 minutes to capture their attention. And if you haven't captured their attention in that period of time, they're thinking about what's important to them, about how can they access their emails without the judge seeing them. How can they're thinking about picking up their kids after court. They're thinking about the laundry. They're thinking about what their next project is. Just like you guys. When you're in here listening, after a while you start thinking about your cases, about what you're going to do, what your planning is. You have to break through this wall that people have, because until you get their attention, you're not going to be able to persuade them. And I want to read to you from an article that was in the Chicago Tribune. There was a gentleman by the name of Conrad Black, no relation, who was a media mogul originally from England and then moved to Canada, owned a whole series of newspapers, among other things, a billionaire, and he was indicted for fraud in Chicago in federal court. And he was put on trial and hired a team of lawyers who were defending him, some of the best lawyers in the country. These were highly skilled lawyers who knew their way around the courtroom. And I read an article, and I have the quotes from the article here from the reporter, and this is how the reporter described what was going on with the jury. They appeared to doze. They stared at the ceiling. They doodled in notebooks, picked at their fingernails, played with their pens. At times the jury was bored silly, and at times their pinched expressions suggested they were having trouble following the case as lawyers flashed documents at them on the courtroom projector. At times, the lawyers did not even bother to explain what the documents were or where they came from. It is the job of the speaker to see that his audience gets the message. It is not the audience's job to get it. It is the speaker's job to communicate it clearly, precisely, and in a way that speaks to them, that they can understand, that interests them, so they want to listen. As I said at the beginning, too often we see PowerPoint presentations that are just bullet points, just lists of text. And one thing I want to mention, one of the least persuasive ways of speaking to jurors or an audience of any type is by putting text up on the screen. You want them listening to you, not reading what's on the screen. You want to put on the screen something that enhances what you're talking about. You don't want the same things that you're talking about on the screen because you're going to lose them. And I have a theory about trying cases, particularly today, about mixing up the media that you use. Think about this. We have blackboards, we have green boards, we have whiteboards, now we have smart boards. We have models. We have pads that you can put up and write on. We have iPads. We have computer-generated materials that can be put up on the screen. We have easels in which you can put blow-ups. We have Elmos in which you can put documents up on a screen while you're writing on them. There are so many ways to communicate. And what I like to do is to use as many of them as I can, because that way I keep people interested. Because the more things you do, the more interesting it is. If you only use one type of media, people get tired of it very quickly. I like having multiple types of media so I get to move around and do different things. In the last case I tried, it's somewhat embarrassing. I was actually trying a case to determine the boundary line between two pieces of property on Star Island in Miami. Now, this is not the sexiest case in the world, as you can imagine, but an important one nevertheless. So, of course, we had a projector like this in which we could put up all kinds of maps and sketches and diagrams and photographs and what have you. But that was not the main way that I communicated. I got a big pad, and I had a magic marker. And what I would do is stand there in front of the court, and while talking, I would start drawing out the properties involved, where the boundary lines were back in 1919, where they changed in 1950, where they were in 1969 when another surveyor came in. And I would keep redrawing these boundaries time and time again on the pad. And I did that not because my drawing was better than what the surveyors can do. Of course, it was totally elementary compared to what these professionals could do. But it communicated to the court that I knew what I was talking about because I was able to draw it. And in fact, what I was doing is harking back to the time when we were all in school, when the teacher would, at least when I was in school, when the teacher would get up and start drawing on the blackboard and writing things on the blackboard, because that's the way we learned back then, before the smart boards and all the new techniques they have today. And there's nothing better than writing on the blackboard or a green board or a pad while speaking, and it is one of the great methods of communicating. And so I recommend to people that you use as many different methods of communication that you can. Now, I want to go back to the Michael Skakel case again. Why am I interested in Skakel's case? The prosecutor in that case gave a 33-minute rebuttal final argument. That argument was so extraordinary and unusual that it actually spawned 7 law review articles discussing the content of it and the consequences of it in that particular case. Skakel was charged with killing a young girl named Martha Moxley, who was a neighbor of his in the very Tony, Greenwich, Connecticut area. This was a very difficult case for the prosecution. It was 25 years old. There were no eyewitnesses. The circumstantial evidence wasn't particularly powerful. The crime scene evidence was inconsistent at best. And that's why it took 25 years before they actually filed charges against Skakel. They didn't even know who had committed this crime. And they finally charged him and put him on trial. So they knew they were going against an uphill battle. They spent 6 months preparing a multimedia presentation that was used in their rebuttal final argument, 33 minutes long. And what did it consist of? They had loaded into their machine over 100 crime scene photographs, the autopsy photographs, all the documents, the diagrams. They digitized the audio and video recordings. They had aerial photographs, all of which had the ability to zoom in and zoom out. They put up pictures of pieces of evidence with the labels on them describing who they are, from the blood found at the scene to having pieces of the golf club that she was killed with. And then they would intersperse in that pictures of her. They had pictures of her carrying her school books to school. They had pictures of her on the autopsy table as a corpse. And what they would do is, while Benedict, the prosecutor, was speaking in those 33 minutes, is every time he would talk about something, they would bring it up. And it could be shown from different angles. And they used different media all the time. And Skakel, among other things, had dictated a book that he was writing about the case. They had that digitized and put up on the screen. They used transcripts from the trial and transcripts of recordings in which they took the important words and put them in red so the jury could not miss them. How significant was his presentation? Dominic Dunn, who now is deceased, one of the great courtroom writers of our time, said, "The summation was as brilliant as anything I have ever heard in a courtroom." Now, that must have been pretty good because he covered 2 of my cases as well. Robert Kennedy Jr., who is Skakel's cousin, said, "The multimedia display really convicted Michael in the end." Jeffrey Toobin, the CNN commentator, said, "Call Jonathan Benedict's closing chilling, riveting, and unforgettable." That's what got my attention, learning about putting together a multimedia presentation. And I know what some of you were thinking. Isn't this expensive? Isn't this over the top? Isn't the jury going to be turned off by it? Isn't it better doing something that's rudimentary, just like, I don't know about you, when I was a public defender, I used to always say I'm an assistant public defender who was appointed by the court, and get across to them that we don't have a dime and we're here on a wing and a prayer. But the answer about whether it was too much was answered by that jury. During their deliberations, they sent a note. Before I get to the deliberations, the defense lawyer, who is a friend of mine, Mickey Sherman, actually said in his argument that they could not match what the prosecutors had put on. That he was only a lawyer with 2 paralegals and didn't have the ability to do the same kind of presentation that they did, and asking, in effect, the jurors to give him a break because of that. Well, what did the jury think of him? During the deliberations, they sent a note to the judge asking him if they could have the prosecutor do his final argument again. Now, what better compliment is there than that? Or what better comment on the effectiveness of a presentation to have the jury come back and ask that you do it again? Have any of us ever had a jury ever say, could you please repeat your final argument? Now, unfortunately, I don't have the I should have put this up while talking about Skakel, because this is what Skakel is all about. I don't have Skakel's multimedia presentation. I've only read about it. But I have a good substitute. Oliver Stone did a movie called JFK, and since we just passed the 50th anniversary of the assassination, it's in people's minds. And Stone did a brilliant structure to his movie that made it different than virtually any other film that I've seen. He had the movie go first with all the scenes which he claimed happened, showing all this conspiracy, and he believed that they were forced shooters, and goes through it all in detail in the film. But that's not what made it so much of an impact. What he does at the end of the film, stealing from us, in essence, he has Kevin Costner, the prosecutor, get up there and argue the case why there was a conspiracy. And what does he do while Costner is arguing his case?
Let's just for a moment speculate.
What he does is he starts flashing up on the screen the scenes that the audience has already seen. These are the actual scenes that went on during the movie. So everything that you see here was shown at some time to the audience. In the essence, just like testimony or exhibits. And what he does is, and I only have one clip here, while Costner is talking not to the jury in the courtroom, but talking to the audience in the theater, talking to people in this country, he is showing everything that happened before, which you've already seen while he's speaking. And it's probably one of the most powerful arguments that you could have, because everybody accepts it, because they've already seen it. So while I don't have what happened with Skakel, what happened with JFK is in the same realm. And I've actually spoke to Mr. Stone, who I've actually gone to dinner with a few times, about how he came up with this. And he stole the idea from a courtroom. That he knew that this would be the most persuasive way of convincing people that his theory was right. If he could get Costner to get up there and actually argue, and at the same time show the evidence while it's going on. How effective was that? Jack Valenti, former assistant to Lyndon Johnson, who became president of the Motion Picture Association of America, thought that this was outrageous. And of course his connection to it was because he was close with Johnson, and in the movie, of course, Johnson seemed to be one of the bad guys. And I think this is probably one of the greatest compliments that a filmmaker can have, to say that this is an incredible piece of propaganda which has convinced the country of something that is totally untrue according to what the Warren Commission did and everyone who examined the case. Yet that is the power that Stone and Costner put together by this multimedia presentation that enhanced what he had to say in the courtroom. And it fits in exactly with my theory about how to convince people. Now, I'd like to make a suggestion to you. I would like you to take out a piece of paper and write this down. And take it back to your office. Put it in bold. Probably Verdana is the best font for that. Punch 2 holes on the top of the page. Laminate it if you can. Hang it on your bookshelf. And look at this every day that you can and live this. Because this is where we are today. This should be your mantra. And why does this work? Let me give you a little bit of the research. Social science has looked into how people learn. We're very interested in educational, how children learn, how people learn, how we can do it better. And what they found is that we have dual channels in our brain. We can, at the same time, listen and take in verbal messages while we have pictures coming into our mind. And they do not interfere with each other because they're 2 different channels. They then merge in your brain, in your working memory. And you're able to consider both of them at the same time and put them together. That's why words and pictures work so well. And these are the conclusions that the latest research has come up with. People learn better from words and pictures than words alone. People learn better when extraneous words, pictures, and sounds are excluded. This means to simplify, to keep out redundant material. Keep it as clean as you can. People learn better from animation and narration than from animation and on-screen text. Text on screens do not work. People cannot learn that way. People learn better when corresponding words and pictures are presented simultaneously rather than successively. Meaning you want the image up on the screen at the same time when you're speaking. People learn better when the words are in conversational style than in formal style. People learn better when the narration is spoken in a friendly human voice. People learn better when a multimedia lesson is presented in user-paced segments rather than a continuous story. So what does this tell you? That you want to talk to people conversationally. While you're speaking to them, you put up on the screen what you want them to see. You want what image you want to impress them with. You want to do this as you're speaking and put them up there while you're talking about it, not later. And you want to do so, as I said, in a nice conversational, friendly voice, because this is the best way that people can learn. And what's the difference between students in a classroom and the jury? I don't think there is any difference. That's how people can learn. That's how you can have impact. It is far better than some type of formal presentation. And putting up a PowerPoint, reading from slides, putting up dense written materials don't work. And what I like to do, and I'm going to go into parts of a final argument that I did in the case a couple of years ago, I like to put up pictures and images and quotations, as you see, because I think that if you have a picture of something that illustrates what you're talking about, there's no greater power of persuasion than that, because it's imprinted on their minds. They remember it better when they've got the visual information at the same time that you're talking about whatever your point is. And that visual imprint on their brain is what helps to persuade them. Now I'm putting this one up particularly because of you guys. I look at this as to what public defenders are. They are the people's lawyer. They know how, or you know how, to connect with people on a level that they can understand. And I think this is important, if I can give you a couple of examples. I learned this back in 1980 in the presidential debates between Jimmy Carter and Ronald Reagan. Now, mind you, I love Jimmy Carter. He was a great person. And I hated Ronald Reagan because he was an ultra-conservative, and back those days, us radicals couldn't stand Reagan. But Reagan was a far more astute communicator than Jimmy Carter. In the debate, they would ask a question, and Jimmy Carter would give the facts and figures. He knew them all like this. He was a brilliant guy. He knew what he was talking about, but nobody ever got what he was saying because it didn't speak to them. Just like in a final argument. You get up there and you give them just the facts, or you repeat what the witnesses said, they're not going to get it. It doesn't mean anything to them. What did Ronald Reagan do? He's asked the same question. He doesn't give any facts and figures. He didn't even know them. I guarantee you, he didn't know what was going on. But his response was what? Are you better off today than you were 4 years ago? Everybody got that. That was his theme. He would repeat it over and over again. Carter could not participate, could not rebut that in any way. And it was clear. And I think Reagan won 48 out of the 50 states. Why? Because he understood his audience. He knew what they wanted to hear. They didn't need those facts and figures, just like in your final argument. What are you doing? You're not just repeating the evidence. You are trying to give the audience what they need to add meaning to what you're talking about. Same thing happened with Bill Clinton. Bill Clinton, who is one of the great speakers of our time, and if you've ever met him, this man is really extraordinary one-on-one. You talk to him, he looks you in the eye, he speaks right to you. If you'd ever met him before, he remembers your name. That's why all these women are always swooning over him. He doesn't look around the room. He only looks at you. And what's the great expression that Bill Clinton used? I feel your pain. I feel your pain. He speaks to the people. They get what he's saying. Now, I also love equally Hillary Clinton. Hillary's like Jimmy Carter. She knows every program, every detail, every fact. She's brilliant. Probably smarter than Bill. But she doesn't have that human contact. She doesn't have that ability to reach out and give meaning to the audience like her husband can. Nobody can beat Bill when it comes to that. And what does the jury want from you? They want to know not just your words, but your attitude. What do you feel about something? People are convinced by emotions, not by fact. When we buy something, what do we buy? We go out to buy a car. We don't look in the engine and look at its 389 horsepower that can go, 0 to 60 in 2.7 seconds. We want a sexy car. We buy the emotion. We don't buy the detail. And I want to give you a quotation. I don't have it up here, but I will read it to you because it just came to me because of what happened yesterday with the death of Nelson Mandela, one of the great men of our time, a man who probably knew how to speak to the people as good or better than anyone else. And what Mandela said is, if you talk to a man in the language he understands, that goes to his head. If you talk to him in his language, that goes to his heart. Isn't that the trouble with lawyers? I've taught for many years at the University of Miami Law School, and I teach a course in trial practice, and I tell lawyers the first thing you have to do in order to be a good trial lawyer is to forget 3 years of law school. You cannot communicate to people in our language, the language of the lawyers. You can only persuade them and communicate to them in their language. And if we don't speak their language, we're in trouble. And what is the measure? I read this somewhere. The measure of a great teacher is not what the teacher knows. It's what the student knows. And people are persuaded not by what we tell them, but by what they understand. And vision without passion does not persuade anyone. Without the passion behind it, without the feeling behind it, it doesn't have any impact. Can you imagine if Martin Luther King Jr. got up there in the mall in Washington and D.C. and said, "I have a plan"? Would anybody remember that speech? It's that vision that gives it that extra something that we will never forget. That passion. And I wanted to, there's a great writer today, Dan Pink, and I would recommend to you his books because he really is a very insightful writer. He understands what's going on today and in the future. And I think that his philosophy, and I wish I could say this better than he can, but I can't, so I put it up there. Now, when talking about multimedia, I have to go back to O.J. Simpson. Seems like ancient history, and actually it is ancient history. But probably the single greatest exhibit I've ever seen in a courtroom was done by the prosecutors in Simpson's case. And it's not really done by the prosecutors. It was actually done by, and I can't remember the guy, Don's name, Donald something. He was the guy who started a company called Litigation Sciences. And he had moved on, was out in L.A., and he volunteered to do all the demonstratives for the prosecution for free. And he prepared this exhibit, which is describing how Simpson could go from his house to Bundy, where the murders occurred, and how long it would take. The genius of this exhibit is that it has six different dimensions. It's got the map, it's got the time, it's got the moving dot, it's got the video through the windshield, it has narration, I don't know if I missed any, and the time. It is absolutely a brilliant piece of work. And you can see I copied this off of Court TV, so it's a little bit cloudy. Oh, and it puts up the name of the street while they're driving. 6 different dimensions being shown to the jury at the same time. It's absolutely a brilliant, persuasive, convincing exhibit. The only thing that's unfortunate for Simpson, not for Simpson, for the prosecution, is that in my mind, this really didn't prove he was guilty. In fact, it may have proven he was innocent because of the time windows that he had to work in are extremely narrow, if not impossible. And I think that's the reason that he ended up getting acquitted. Now, I want to speak to you for a minute on something that I really firmly believe in, and I tell this to my students all the time. There are many books on trial advocacy that teach you how the great lawyers tried cases. And, the final arguments, the cross-examinations, the opening arguments, all of that. And I tell students that all these books about these lawyers that have been written for I don't know how many years are absolutely worthless. And you ought to throw them out. And don't waste your time reading any of them. I tell them, instead of reading books on trial advocacy, read business books on marketing and persuasion. I know that sounds radical, but let me explain why. Businessmen are far ahead of us when it comes to persuasion. Over 100 years ago, Dale Carnegie. Dale Carnegie started teaching courses in public speaking. And Carnegie learned from the great psychologists who were just then beginning to describe how the human mind operated. And in essence, were telling people like him how to persuade people. And he started using all these psychological principles in his course on public speaking. This is before he wrote the book How to Influence People and what have you, which is somewhat different kind of viewpoint. He started out with public speaking, about how people can get up and talk to people, because the new type of business had been created, large corporations in which managers had to speak to people. You had to get marketing out there. You had to persuade people to buy your goods and services. This is what business is about. How do you persuade people to buy something? And so what did they do? They learned these psychological principles. While we were still learning things they were doing in the 18th century, business people who had to make a living on selling, on getting their ideas across, on marketing, on communication, spent their time and effort in research into how they can convince people to buy their products. How did Leo Strauss actually create, I think he took drapes or something and created blue jeans out of them and could sell them to people? Bill Gates said, my vision, my mission is to put a computer on every desk, and everybody laughed at him. Steve Jobs, who was probably one of the greatest presenters of our time and worth your study, didn't say, well, we'll buy my iPod because it has great music in it and what have you. What did he say? Put 1,000 songs in your pocket. These people understand how to speak to an audience. These trial advocacy books don't make it, ladies and gentlemen. Buy these business books on persuasion, on marketing, because they're going to tell you a lot more how to reach the people that you want to talk to. Sell is a 4-letter word, but it's not an expletive. We all are involved in sales. Every one of us. We more than most people. And not only that, but we're traveling salesmen. We sell, what do we sell? We don't sell cars. We don't sell computers. We sell ideas. We sell themes. We sell arguments. Everybody is in sales. I know it sounds pejorative. You don't want to think of yourself like that because we're professionals. We're above that. But we're all in sales. We are there to make the sale, to close the sale, to convince people, to persuade people, to influence people. And one thing salesmen have learned from the beginning of time that we should take to heart: you cannot convince somebody to buy something by boring them to death. Now, I wanted to show you a little bit about how I use these principles when I try a case. A couple of years ago, and let me give you a little background, I represented a man by the name of Elio Castroneves. And Mr. Castroneves was a race car driver, had won the at the time of the trial, had won the Indianapolis 500 5 times. And one of the great stories, at least in my life, is after he was acquitted, he walked out of the courtroom and 2 weeks later won the Indianapolis 500 for the third time. But he was charged with tax evasion. And it was a very complicated case. He was charged with failing to pay the United States government $6 million. And he had a very Byzantine method of getting paid, where money would go through an anonymous Panamanian corporation with bearer shares, then would move to somewhere, a bank in Anguilla, and would end up in a bank in Holland. And of course, all of these transactions, and this is only a small percentage of them, were never reported to the United States government. And I know that you don't try tax evasion cases, but I can assure you that the United States government gets really pissed off when you don't give them at least half of what you earned. So they indict him, and we have to try this case dealing with a lot of money. And I know that you try very difficult cases. And when I was a public defender, I tried the gamut of cases all over, in the last 3 years of which I only handled the capital cases. It's one reason I had to quit. I couldn't take it anymore. And I always thought there would be nothing more difficult than that. But I will tell you, when you try an income tax evasion case, the jurors are really upset. Because they all say, you would think that they come in there and nobody likes the IRS. And so you would think, oh, intuitively, the jury's going to be on my side because they all hate the IRS. But it's just the opposite. Their attitude is, I'm paying my taxes, how come this schmuck isn't paying his? And I'm telling you, it's a very hostile kind of relationship. So what I try to do is, first of all, try to get them to understand that our government is not the nicest people on earth. Now, I must admit, I've loaded this slide a number of times, but I've never used it because I've always thought it's a little bit over the top, and probably the next one is too. But I like it because these prosecutors are always talking about they're the government, and I like to really explain what the government really is. Now, the next slide I have used many times, and I absolutely love this photograph, which is called Tank Man. And I don't know, I'm sure most of you know about this, but this is an iconic photograph that happened at Tiananmen Square, where this man in the white shirt and the grocery bags goes out and stops the line of tanks. There's something about photographs. I love photographs. I love to use photographs. And I like to talk while putting them up there on the screen. Because if I'm talking about courage and standing up to the government and speaking to power, I can say it all day long. But this picture tells the story better than I can. A great picture tells a story. And this picture, to me, is one of the iconic photographs, and I love to use it because it really tells the story. I also like to explain to people the problem with income tax. My client was a Brazilian citizen whose first language was Portuguese, dropped out of high school to become a race car driver, came to the United States on one of those special visas that they have for athletes and what have you, And they expect him to know how to pay his taxes. If you read 200 pages of the Internal Revenue Code and regulations a day, it would take an entire year, 365 days, to read the entire code. And at the end of that year, you'll find out they've already changed it. In the year we tried the case, I think it was 2010, they changed the code 575 times, so you'd have to start all over again. Nobody has read the entire code. And in fact, what I always tell them, Will Rogers has a great quote. He said, if you cannot understand something, you can be sure it was written by a lawyer. This is written by lawyers. People cannot understand them. And what else? I actually stole this from one of the pages of the Sunday New York Times, which I think explained his problem better than any other. He was caught in a maze. He didn't understand this kind of thing. No single human being, certainly not somebody whose English was not their first language, could read these things and know what to do. The point I wanted to get across to the jury is that no human being is going to be able to do that, not even some of the world's most intelligent people. General Electric has 1,000 tax lawyers in its legal department. 1,000 tax lawyers in order to figure out how to pay their taxes. It costs Americans 11 cents for every dollar that they pay in taxes, because you have to have bookkeepers, you have to have accountants, and you have to have lawyers describing and telling you what to do. Nobody knows on their own how to file income taxes. I wanted to get across to the jury how difficult this is. And here's what has been universally acclaimed as the world's most intelligent man. When he died, we preserved his brain so we could examine it. And if this guy can't pay his taxes, how do you expect my poor client to be able to pay his taxes? The prosecutors, they do it in every case, so of course I knew they were going to do this. Their main argument was, feeding into what jurors actually believe, is that Elio did not pay his fair share of taxes. They always argue this. The citizen didn't pay their fair share of taxes. And this is a myth. So of course, what I did was try to explode the myth. Higher rate than he did. And I think it was Warren Buffett who said, I pay at a lesser tax rate than my secretary does. So there is no fairness in the tax code. And by the way, I like to tell people they call it the tax code because it's in special coded language that nobody can really understand. Also, at the same time, we had this gentleman, Timothy Geithner. He had just been nominated to be Secretary of the Treasury. Geithner, before being nominated to be Secretary, was Chairman of the Board of Directors of the Federal Reserve Bank in New York. He is a financial wizard. He has now been head of the Treasury Department for the last 5 years, but this is the time of his, right after his confirmation hearings. And what happened at his confirmation hearings? It turned out that he improperly reported his retirement account. And he didn't pay taxes on money that he was paid that he put into his retirement account. And guess what my client was charged with? That he did not properly report income that he was not taking in the particular year, but he would take in a future year as part of his retirement. Now what happened when Geithner went before Congress? They brought out that he hadn't paid his taxes on this. What did everybody say? Well, it was just an honest mistake. The man who's a financial wizard, who knows more about finances than anybody else, made a simple mistake in calculating how his retirement income should be reported. Yet my client, who left in the middle of high school, is supposed to figure out the same thing. And the part that I really liked about this, using Geithner's photograph, is not only was he Secretary of the Treasury, but as Secretary, one of the agencies that he supervised was the Internal Revenue Service. And when it came out that he had not reported his income, they not only did not charge him with a crime, they not only did not fail to confirm his appointment, but they even excused him from paying the civil penalties and the taxes that were owed. Let's think of the hypocrisy of that. And so I love the idea about mistakes. I use this all the time in my arguments about how mistakes are made. And I like to illustrate that nobody is above mistakes, not even the United States government. One of the vignettes I like to use, although I used it then, but now people are not going to remember. When Barack Obama was sworn in as president, John Roberts, the Chief Justice of the Supreme Court, administered the oath. And these two men, who were two of the brightest men on the face of the earth, two of the most accomplished men, two men who had prepared for this moment that was in front of, I know I was there that day, I can't remember, at least 500,000 or 750,000 people live. It was on television being shown around the world, an incredible event in which Roberts was giving the oath and Obama was taking the oath, and the oath is 35 words long, 35 words long, and they got it wrong. Two of the smartest men on earth. And yet they want to put my client in the penitentiary for making a simple mistake on his taxes. And if I was arguing this today, even though I love Barack Obama, I would use Obamacare as my theme if I was arguing a mistake. A 15-year-old kid could have got this website correct, but not the United States government. And I love to batter the government. And I like to say that we have the intelligence agencies that we pay $30 billion a year to in order to give us information. And yet, what happened? We invade a country looking for weapons of mass destruction, and they don't exist. After spending $30 billion, that's what we get. And by the way, have they ever balanced the budget? In every case, I know that you argue presumption of innocence. And I'm always looking for new ways of arguing the presumption of innocence and reasonable doubt. And I'll get to reasonable doubt in a minute. But first is the presumption of innocence. We all believe that this is an absolute sacred part of our rights as a citizen to be presumed innocent when we're charged with a crime. And I like to tell them I remember learning about it in law school, about how great this was, and learning about Blackstone, about 10 guilty men should be let free before one innocent will suffer. And that has become a cliche. And guess what, ladies and gentlemen? The jury doesn't care what some judge 500 years ago had to say. What do they care about? When I argue the presumption of innocence, I talk about what's going on today. I said we used to presume people innocent, but not any longer. Because today we have people demanding that everybody is guilty. Everybody is a person of interest. Everybody is guilty of something. And you hear it all day long. The presumption of innocence has been devalued, diminished, if it even exists. And I like to tell them, think of the consequences of this. Think of what the DNA revolution has done in this country. Over somewhere between 300 and 400 people have been released from prison after they've been convicted by a jury, affirmed on appeal, because later they found DNA that proved they were innocent, actually innocent. Let's look at the Michael Morton case in Texas that people might remember. 25 years in jail, although he was totally innocent, and yet the jurors convicted him. And I say this is because the presumption of innocence no longer has any force and effect, and it's up to you to breathe life back into this rule. Because it has been so much diminished, it's easy to convict people, and we load the prisons full of innocent people because we presume everybody's guilty. And everything, every little piece of evidence we look at in some type of a sinister way to say that this means that they are guilty. The DNA has exposed the flaws in our system of justice. Now I'd like to talk to you about reasonable doubt. Reasonable doubt, you argue in every case. The jury listens to the jury instruction on reasonable doubt. It is absolutely worthless. It doesn't mean anything. It doesn't give the jury what you want to convey to it about how high a burden this is. There has to be some way of explaining this, and words seem to be inadequate. There has to be some way of getting it across to people. And I've struggled with this for a long period of time, and I'm going to go through here some of the evolution of my thinking on it. This is a PowerPoint on what reasonable doubt means. This is where we started, and it's totally worthless. This doesn't mean anything to anybody. This doesn't get across what reasonable doubt is. So we started thinking about how can we illustrate this. This little box, use that, pass that up right away because it really didn't work very well. Then we had this thing on levels that we thought perhaps would be a way of illustrating what's going on. Then I came up with this one. It looks like a Pythagorean theorem, a sort of a right angle triangle. And to be honest with you, after a while, I don't even know what this meant. So, if I can't figure it out, how can the jury? Then we started going to cylinders, which I like, are the nice colors, and to go through how, trying to get across to them how important this is. And we went through a number of different variations of this, which I think are interesting, trying to illustrate to them what it means. And then I got to degrees of guilt. That sounded good, sort of like this little thermometer over there, telling them, about how hot it had to be before they could convict. And then we would sort of, change that around a little bit. Sometimes the thermometer was low, sometimes high. Then I came up with this one. I like the colors of this one, but it really didn't have any power to it. It didn't show how difficult that it was. So we started working with this one. I like this because it has so many more levels. That's the real genius to it, trying to get them to understand how much it was. And so then we started adding some more because I really like this idea, and as many as we can put in there, I would want to put in there. And then finally the second to last one, I got this one. Because I wanted them to, anytime you can put not guilty up there, and you have all these levels, it works good. But then I think there's a better way of doing this. Of course, I didn't have those transitions. So what I like to do is start doing them one by one. So when I'm talking about them, I actually put them up on the screen one by one, and I'm describing to them what this means, each one of these levels. Because I want them to think that in order to be guilty, it has to be so far beyond this as to be almost impossible to reach. And I think that's the way to illustrate what reasonable doubt is about. At least that's what I've been able to get to so far. And I've struggled with this, as I said, over the years, trying to figure out how to do it. And I wanted to talk to you about one other way of doing it. Back when I first started practicing law, there was a man named Jacob Bronowski. He was a guy who was a mathematician at the Manhattan Project, one of these absolute geniuses, but a polymath who studied virtually everything. And he created a program called The Ascent of Man, in which he described how mankind developed over the ages and discussed the great advances that occurred in man's thinking. And that's not what I thought was important, although it was a great series. There was a episode where he goes to Auschwitz. And he goes behind the crematorium, and he's telling the audience that his family had died in the Holocaust, that they were probably ashes that came out of that crematorium. And he goes in the back of the crematorium, and he gets down into, there is a dirty, scummy pond there. And he walks into the pond, and he gets down on his knees. And I'll never forget this moment in which he goes down there and grabs up some of this mud, and he holds it up looking at the camera. And he wants to describe to them the horror of thinking that his family could be part of that mud from the ashes from that crematorium. And he's trying to make the point about the danger of men who are so positive in what they are doing, whether they're Nazis or Stalin or Chinese or whatever government it is. And he gets on his knees and he looks up at the camera and he quotes from Oliver Cromwell back in the 17th century, in which Cromwell was arguing against the death. And he quotes the words of Cromwell and said, "I beseech you in the bowels of Christ to think you might just be wrong." Ooh, I can't even walk anymore. And I always thought that that was such a brilliant way of putting it together. Maybe better than this. Each one of you has a unique contribution to give. The world is full of many accomplished lawyers, and I'm sure you see them on a daily basis. You've watched their cases. You may want to be like them, but that's a mistake. You are a unique person, and the most important thing is doing the best that you are able to do, because you can't imitate somebody else because they're taken. You want to enhance your abilities. And I hope some of which I've said here today will assist in that. And I think that you need to have fun while doing it. By fun, I don't mean that you're going to get up there and tell jokes and you're going to communicate like that, but that you enjoy what you're doing, that you know that you want to be able to communicate with people, that you are authentic and have sincerity. No matter what you do, if it comes from a place of authenticity, the jury will love it. if you are unique, if you are speaking in your voice, and they hear that you are authentic, it has an incredible power. And I was thinking about that this morning. I was watching CNN, and they had somebody on CNN who said that, could you imagine what Nelson Mandela could have done if he didn't spend 27 years in prison on Robben Island, in solitary confinement, in a place that's cold and bitter, if this man had not spent 27 years of his life there? But they were wrong. The reason Nelson Mandela was Nelson Mandela is because he spent those 27 years in prison, and he came out and was not a bitter man, that he came out and changed the world. Those 27 years in prison gave him authenticity, gave him the sincerity. When he spoke, people would listen. So saying that those 27 years was wasted, I think, is just the opposite. It was those 27 years that allowed him to destroy apartheid, to destroy racial injustice, to give him the voice to speak to people that nobody else had, because he was the one person who could do it. And so I think that not only do you want to have fun doing it. Thank you all very much.